Now, in this video clip, the thought of deceit or a fraud in dairy versus fairy. The fraud may be defined as false representation made knowingly without any in its truth or recklessly, carelessly, whether it is to be true or not. The tort of deceit provides civil remedy for individuals who relied upon false representation to determine requires the following elements to be proved. The elements of the tort. The defendant made false representation by word or a conduct. Uh, the false representation must be made with intention that it should be acted upon by the plaintiff. The plaintiff must have acted upon a false statement that the plaintiff must have suffered damages by acting upon the false representation made with the defendant, that the defendant must have made in the absence of any genuine belief that it is to be true. Examples of deceit. The example when a tort of deceit will come into play is where the individuals have made a false insurance claim to their insurer in the case of motoring accident. If, for example, they claim that another party has damaged their vehicle in a collision, but it is in a fact it was their own fault. The original statement has caused the insurance company to pay out. The individuals will be liable for the insurance company under tort of deceit. The elements of the claim of the deceit. First one is a false representation. There must be a statement written on oral conduct amounting to a representation which is false. The statement obviously involves something being said or written, whereas the conduct consisting of wearing uniform or dress of some kind would be included. Mere silence would not be considered as a false representation. Second is of fact. The misrepresentation must be in relation to a specific fact, that is, the facts of motoring case. The statements of opinion or intention therefore do not fall within definition of false representation, knowing or reckless whether the statement is false. For the tort of deceit to be actionable, it is not enough that the defendant were negligent as to whether the statement was false. The defendant has to know the statement was untrue to be reckless as to the truthfulness. Anything less than this is not enough. This is a substantive test as relating to the defendant's actual knowledge state of mind. That there was a reliance upon misrepresentation. The representation does not need to have been made the sole reason for subsequent action leading to loss. It need only to material in the act. It was one of the factors which lead to act course of action. Damages. The damage or loss must suffer because of deceit. Then what are the remedies for the deceit or a fraud? What relief can be provided in a claim for deceit? As most claims of deceit is for monetary loss, the most appropriate remedy to be provided will be the damages. Damages in relation to time taken by insurers, claims or departments investigate to deal with and investigate the claim. Disbursement incurred by the insurer, the repair cost to the vehicle of the policyholder who has made fraudulent claim, the payment which has already been made to individual through the policy. If someone is induced to enter into contract and based of false mispresentation, there may be a rescind the contract, claim damages for any loss occurred, that is exemplary damages. And move on to the next topic, that is called malicious falsehood. The law of malicious falsehood aims to protect the economic interest. Malicious falsehoods are sometimes made in tandem with as an alternative defamation claims. Although both malicious falsehood and defamation claims deal with publication of false statements, the main difference between them is that the claim in malicious falsehood is not required to prove damages repetition. Another advantage is that the single rule does not apply to malicious falsehood claims. There may be a tactical reason for bringing up claim in malicious falsehood rather than defamation, although the damages tend to be lower. The claim for malicious falsehood may be brought against the defendant who maliciously published a false statement which identifies the claimant. His business, property, and other economic interests can be shown to have caused the claimant financial loss or to fall within one of the exceptions of Section 3, Subclause 1 of the Defamation Act 1952, England. The typical situation in which the claim for malicious falsehood arises where one competitor has made untrue statement about another goods and services which is calculated to cause financial loss. The slender of goods or title are types of malicious falsehood. Elements of malicious falsehood. What does claimant need to show? The malicious publication. First one is malicious publication. Defendant must have intended to publish statements complained of, have done with improper motive. Evidence of malice might include proof. The defendant knew that relevant statements are false. The defendant was reckless as to the truth or falsity of the statement made when publishing them. That even though the defendant believed the statement to be true, their dominant motive in publishing the statement was injure the claimant interest. Falsity, second one is falsity. It is up to the claimant to prove the statements complained were untrue, unlike in defamation claims, where falsity is presumed. The burden falls on defendant to prove the statements are true. Furthermore, the statements complained of, even if false, must be their merry puff between two trade rivals, such as often seen as comparative advertising. There is no defense equivalent to honest opinion defense available in defamation. This means the defendant cannot contend the interference is one of the honest one, inference is one of the honest one and could be believed to be true. Identification of the claimant. The claimant the claimant or a claimant business, property, economic interest must be identified, whether by way of direct or indirect reference. Financial law. The claimant must demonstrate the statement has caused actual loss unless it falls within the exception of 1953 Defamation Act. If words upon which the action was founded are calculated to cause pecuniary damage to claimant are published in writing and other permanent form. If said words are calculated to cause pecuniary damage to the claimant in respect of any office, profession, calling, trade, business held, carried out by the time of publication. The use of word calculated in 1952 Act is to read meaning more likely than not. Relying upon the claimant must identify the nature of likelihood, the mechanism by which loss would be incurred. Remedies. The remedies for the malicious falsehood is damages available to claimant which can demonstrate the statement complained of caused the actual financial loss or if the statement falls within exceptions likely to financial loss. Both interim and final injunctions may be available. And we move on to case laws pertaining to malicious falsehood. The Chartered Bank versus Pakistan National Shipping Corporation 2002, 3 WLR 1547 UK HL 43. The fraudulent bills of lading has been issued in order to rely upon letters of credit issued by the bank. The director signing bill sought to avoid personal liability, saying it was an act of company. Defendant company also appealed on basis of claimant bank had made itself been fault and contributory negligent. Our court held that in case of a plaintiff, the fault means negligence, breach of statutory duty, or act or omission that would give rise to common law defense of contributory negligence. Under Eddington, if a fraudulent representation was relied upon, other reasons for making payment was irrelevant. As to the liability of director, his representation was also that of company and did not escape personal liability. Lord Hoffman said that if the fraudulent representation is relied upon, in the sense the claimant would not have parted his money if he had known it was false. And it does not matter, he also had some other negligent, irrational belief about another matter, but for belief would not be parted with the money either. The law simply ignores other reasons where he paid. In another case, Derry versus Peak, that is 1899 14 AAPP CAS 337, false representation. In prospective release by the defendant company, it was held that the company permitted to use trams that were powered by the steam rather than by horses. And in reality, the company did not possess such right as this had to be approved by the Board of Trade. The gaining the approval of such claim from board was considered a formality in such circumstances, and claim was put forward for prospectors with this information in mind. However, the claim of the company for this right was later refused by the board. Individuals had purchased a stake in the business upon reliance on the statement brought by the claim for deceit against the defendant business after it became liquidated. issue here is it is important to note that the law regarding false representation was still developing. This was an important case in doing so. In this case, the court was required to assess the statement made by defendant company in its prospect to see whether the statement was fraudulent and simply incorrect. The claim of shareholders was rejected by House of Law. The court held that it was not proved by the shareholder. The director of the company was dishonest in his belief. The court defined a fraudulent mispresentation as a statement which is known to be false, the statement made recklessly or carelessly as to the truth of the statement. On this basis, the plaintiff could not claim against the defendant company for deceit. Injurious falsehood. Injurious falsehood refers to a statement that may be actually cause reputational damage. In alleged cases of injurious falsehood, the focus is on effect of the statement on the commercial interest of the company rather than any personal offense taken, which is considered in case of defamation. Many people consider defamation proceedings, injurious falsehoods are going hand in hand. Unfortunately, this generalization can backfire. The four elements required to succeed in action for injurious falsehood. There must be a false statement of concerning the plaintiff's goods and business. The defendant must have published the statement to the third person. There must be malice on the part of the defendant. The plaintiff must prove that there has been actual damage as a result of the statement. The failure to satisfy these elements will be fatal to the claim, and subsequently the obtaining successful result for injurious falsehood is very difficult. Malice. The statement must have been made with malice. The ordinary definition of malice is a desire to harm someone. What this means is you need to show the person who made a statement about your goods and services intended to inflict damage on you or business. Alternatively, it can sometimes be accepted the statement was made recklessly without any verification of the truth. It could still held as an injurious statement. Much will depend upon the facts of the case. How actual loss suffered. The plaintiff must show that there have been suffered actual loss as a result of statement. It would be helpful for proving that this could show the people cancel their currency orders or stop doing business with your company as a direct result of the statement. The court, however, may consider less precise evidence. Again, it will depend upon individual circumstances of the case. The key note here is that you should consider injurious falsehood a false statement made and affect your business reputation and set out about there was essential element that must be met without which the claim will not succeed. Defamation and injurious falsehoods are complex areas of law which warrants careful consideration of a particular facts and circumstances of each case. Unfortunately, it is not enough to simply show the claimant's feelings were hurt by someone's statements and make sweeping statements about loss suffered in the claimant business without any evidence. There are more important elements that court needs to see before it will make finding in the claimant's favor. Okay, thank you.